Hello and greeting everyone. Hope all of you are doing well. For today's video we gonna discuss why Computer Crime Act 1997 being introduced in Malaysia based on Dworkin's right thesis. Hope you guys enjoys. We hope everyone can give full attention in this session. In this video we gonna discuss a little bit about Dworkin and 3 stages of law interpretation, which are pre-interpretation, interpretation, and post-interpretation. Who is Dworkin and what actually Dworkin's right theory? Ronald Dworkin was born in 1931 in Providence, Rhode Island, United States. He was an American philosopher, jurist, and scholar of United States constitutional law. Dworkin studied philosophy at Harvard University and, informally, at Oxford University, and also law at both Oxford and the Harvard Law School. Ronald Dworkin, who has died aged 81, was widely respected as the most original and powerful philosopher of law in the English-speaking world. In his books, his articles and his teaching, in London and New York, he developed a powerful, scholarly exegesis of the law, and expounded issues of burning topicality and public concern, including how the law should deal with race, abortion, euthanasia and equality. Dworkin's right thesis involves the general claim that within legal practice and a proper understanding of the nature of law, rights are more fundamental than rules. Rights are trumps in Dworkin's theory, which means that if there is any right which comes into conflict with any policy, the right must prevail. Legal rules and principles for Dworkin exist to express and protect rights in the legal order. For Dworkin, the central approach within law emphasizes rights and the protection of the individual, including the protection of minorities who are left out of the consideration of the utilitarian. Unlike the legal positivists, Dworkin insists that you can't think of law as just rules. The idea that laws are rules induces distortion in legal reasoning. Instead, we must distinguish rules from principles, policies and other non-rule standards. Next, we're gonna discuss how law shall be interpreted based on Dworkin's right thesis. Dworkin's theory is interpretive. The law is whatever follows from a constructive interpretation of the institutional history of the legal system. Dworkin argues that moral principles that people hold dear are often wrong, even to the extent that certain crimes are acceptable if one's principles are skewed enough. Dworkin divided into 3 major stages for certain law to be interpreted, which are pre-interpretation, interpretation, and post-interpretation based on his right thesis. In the pre-interpretive stage, a participant identifies the rules and standards that constitute the practice. Then, in the interpretive stage, the interpreter settles on some general justification for those elements identified at the pre-interpretive stage. At the post-interpretive stage, participant adjusts his sense of what the practice really requires so as to better serve the justification he accepts at the interpretive stage. Pre-interpretive stage. The rapid growth of information technology has brought many new applications with it, such as e-commerce and global business. The past few years have seen legislative efforts addressing topics such as digital signatures, international recognition of electronic records, and data security and privacy. Both the developed and developing countries showed a growing interest in adopting the IT climate. Nevertheless, the securement of this electronic system from interference remains problematic. Many governments worldwide have come up with specific legislation criminalizing hacking. With the introduction of its Computer Crimes Act 1997, Malaysia joined the list of countries with computer-related legislation. Computer Crime Act 1997, CCA, is an act to compensate for computer abuse offenses. As of June 1, 2000, the Computer Crimes Act 1997 created many offenses related to the abuse of computers. The Computer Crime Act criminalizes the act of obtaining unauthorized access to computers or networks, spreading malicious codes, example malware, worms and Trojan horses, unlawful alteration of any computer program or data, as well as wrongful contact to an unlawful individual with any means of accessing a device. Based on the form of crime committed, the fine for a convicted offense ranges from Rm 25,000 to Rm 150,000 or 3 to 10 years imprisonment or both. Back in time, there is no single cybersecurity law in Malaysia. In June 2017, Malaysian Home Minister Ahmad Zahid Hamidi declared that a new cybersecurity bill would be drawn up and tabled in Parliament to counter cyber crimes, including militant recruitment and financing, money laundering and online gambling. Interpretation stage. The term computer crime now appears in the legislation of many countries. Computer crimes comprise 2 overlapping domains. The first one is illegal activities through the use of the computer, such as software and data. These include hacking, denial of service attacks, unauthorized use of services and cyber vandalism. The second area is the protection of information, which related to the protection of information from unlawful use and distribution, which include intellectual property laws, privacy laws, data protection law, and others. In Malaysia as elsewhere, there has been an increase in the number of internet providers, and in the number of users. The growth of the internet has meant more windows of opportunities for computer crimes. To anticipate such abuses, the Malaysian parliament has passed several pieces of cyber-related legislation since 1997. Malaysia Computer Crime Act 1997 has been drafted to provide offences relating to the misuse of computers and to complement existing criminal laws. Hacking or computer crime is not defined in the CCA, but the word used is unauthorized access to computer material. Section 3(1) provides that a person shall be guilty of an offense if he causes a computer to perform any function with intent to secure access to any program or data held in any computer. The access he intends to secure is unauthorized and he knows at the time when he causes the computer to perform the function that is the case. Computer Crime Act 1997 were introduced due to the increasing number of internet user and rapid growth of information technology in Malaysia, which opened more doors for computer crime. This act implemented to combat against illegal cyber activity plus for data user protection. This act also serve as legal right for the victim. Moral behind such implemented is for computer ethic. Computer ethics essentially protect individuals online from predation. They prevent breach of privacy, identify theft, interference with work and unlawful use of proprietary software, among other events. Computer ethics govern the behavior of users online, and date back to 1992. Post-interpretation stage. Before we go deeper into this Computer Crime Act, first let's see what Malaysia can learn to other countries such as United Kingdom, Singapore, and United States. United Kingdom Computer Misuse Act 1990. The UK computer crimes legislation is the Computer Misuse Act of 1990. Government departments in the UK are being attacked an average of 84 times a week by hackers. The government recently proposed amendments to the CMA to update it with more expansive provisions and stiffer penalties. Some of the proposed amendments was to give the police and judiciary the greater legal clarity when dealing with computer crime. The proposed changes would alter the law regarding launching denial of service attacks, the creation of tools that could be used for hacking and bot attacks. Singapore Computer Misuse Act 1993. The main legislation dealing with computer crimes in Singapore is the Computer Misuse Act 1993, CMA, modeled after the United Kingdom's Computer Misuse Act 1990. The CMA was further amended to address new attacks that had evolved with the spread of internet. Thus the act meted out harsher punishment for offenders who secured unauthorized access to such systems. The number of cybercrime cases in the year 2001 was 137, and this figure rose to 151 in 2003. The Singapore government has given this issue a great attention due to its seriousness and high impact on Singapore economy. United States Federal Computer Intrusion Laws. Following the September 11, 2001 events, the CFA was amended to significantly expand the Justice Department's ability to prosecute those who commit computer crimes anywhere in the world. Due to its political structure, computer-related crime legislation and enforcement remain largely under state jurisdiction of prescription, adjudication and enforcement. Nearly every major corporation in the US has been victimized by computer crimes in the past 10 years. Those reporting their organization experienced unauthorized use of computer system in the last 12 months increased slightly from 53% in year 2004 to 56% in the year 2005. Based on the information presented above on computer crimes in the 3 continents, it seems that Malaysia is in a position to learn something from the experience of others. Malaysia has to ensure that they are able to embrace new circumstances without having to be amended or undertaking systematic reviews of their legislative requirements with respect to the prevention and control of computer-related crimes. Despite the global agreement on the seriousness of the problem of computer hacking and other forms of computer crimes, before Malaysia can implement this aspect, there must be a global agreement in order for Malaysia to get the cooperation of other countries. Before Malaysia can implement this aspect, there must be a global agreement in order for Malaysia to get the cooperation of other countries. There will be many scenarios and problems in regard to this. One problem is the determination of where the offense occurred in order to decide which law to apply. The other issue is unless there are proper extradition treaties between Malaysia and other countries, a criminal action against a foreign hacker might be difficult to prosecute even though it has been detected. Another problem is obtaining evidence and ensuring that the offender can be located and tried before a court. We must also seriously question whether the criminal law is the best way to tackle hacking. In conclusion, Malaysia is still in to review back Computer Crime Act 1997 in term of procedural before it can be executed properly in Malaysia. With that, thank you. Presented for Madamani Munirah. Prepared by Zaiful Amin.